The second
First supplementary came on 22nd January 2019.
20.
And the second supplementary in which he has been.
I'm not there at all.
No, second supplementary you are there.
Second supplementary is
4th October 2019.
Thank you, sir.
Very good. Yes.
sir. Now, the main thing about terror funding was a story that one Mr. Wani, a protected witness, carried 75 lakh from some very suspicious source to Shabir Shah. And the prosecution story itself that he was apprehended on the way, so the money didn't reach me, but he was apprehended and it was meant for Shabir Shah.
Okay.
That is the story. Now, taking it at its highest, on face value, Wani is acquitted. Show me that. Just give me that. Wani was acquitted in the UAPA case? In the ED matter relating to the same 75 lakhs. I wrote it down. Where did I write it down? Where did I write it down, man? Wani was acquitted in the ED matter.
Yes.
And my lord, as far as I am concerned, I was given bail in the ED matter. And I was given bail in the ED matter relating to this money coming in and so on and so forth. The rest I must show your lordship, but I don't think it sort of justifies the keeping a man in jail for so long.
Since when are you in custody?
Now, my total custody, according to me, in the FIRs is altogether 40 years. In and out, in and out, in and out.
No, that is with respect to different FIR.
crimes,
Different
crimes.
FIR.
Present crime.
In this 8 years, in this 6.5 years.
Because
in the last FIR.
19 October, the second supplementary came. Only
Yes.
then they would have arrested you.
Yes.
Sometimes like that.
Yes, sir. July. So, my lord, the period of custody that I've undergone in the FIRs is total. In the no, not this one. Altogether, how much? 40 years. 40 years, including detentions. So, your lordship will remember when I said 39 years. Something. My colleague on the other side,
6 months.
took me to task. He said, no, it's 139 days or something, 83 days or something. Now, of course, in his latest thing, he recants to some extent, but I will make good my case. That absent a little mistake here and there, I've been in jail for 39.
You may be in jail for committing different crimes.
No, I'll come to that. In 27 FIRs. And each FIR is approximately the same case. He went to a place, he gave a speech, people threw stones, he was taken. So the speeches come at least maybe 27 times to the court. The very same speeches, the very same
thing. Difficulty is every time you are granted bail, you come out and start giving speeches.
I don't come out actually, my lord. Because
where have you been giving speeches then?
No, my lord, I don't come out because... Wait, I'll answer the question. Because, my lord, on the basis of that FIR, I am detained for long periods of time again. Very long periods of time. So an FIR will come and then I'm detained. 2 years, 3 years, 4 years. Then an FIR, then again detention. So I have to show you all that, my lord. I understand what the effect of those speeches are, what the effect of this terror funding is, and so on. But I have spent a very long period in time. So I have to show your lordship first the charge sheet. What the High Court does, the High Court takes, now in 96, 93, my lord, the all-party Hurriyat conference begins. 93, my lord, all the actors come together and there are allegations against everybody. 96, I leave the all-party Hurriyat conference. The prosecution cases that I've left, the Hurriyat conference, and start some other organization. All the allegations are against the all-party Hurriyat conference. That's the charge sheet I must show. But the mistake made in the High Court was so egregious. Everything that is said in the charge sheet against the all-party Hurriyat conference is taken as charges against me. So that's the basic mistake made. Whereas none of those charges are made against me at all. So that's the first big thing that I want to point out. Now, my lord, with that as background, kindly see the charge sheet, page 123. I'll take except that your lordships get a birth.
One more thing, Mr. Gonsalves. All the previous FIRs against you
Yes.
are only relating to provocating speeches, hate speeches.
That
And
is my understanding, my lord. We don't have all the FIRs against me as well, but whatever we have, we put. But according to me, it is almost virtually the same. There's nothing in the FIR which is not already in this.
And what is the status of your custody or release in those FIRs? They are the earlier ones?
So we actually, the detentions, we have got a few detention orders. He was left with his wife and his two young daughters, who were very young actually at that stage. So they don't even have the detention orders, nothing. When I filed the case,
That
And he
detention
said-
was house custody.
no, jail.
Okay.
1 second.
Not in fact, if I may just be permitted, there was later the affidavit they filed about the period in custody. I filed a reply. I have the letter from Tihar pointing out where he's been in custody, how long, as also from
I've seen that.
DG prison, Jammu and Kashmir. That's on record, which gives the details of the cases and the offences.
I've seen that. So now
what are the nature of cases I wanted to know?
Lord, I'll tell you, Lordship. Lord, the cases in Delhi, Lord, there was an ED case. Thereafter, Lord, there's UAPA 121, etc. Not similar, by and large, similar cases, not. And some we don't have the details of. Some maybe. Yes, but by and large, those are the cases, not. And from DG prisons, I'll just give me a clearer copy. Crazy chap. But from the Tihar, we don't have the details. We just have from Jammu and Kashmir, we don't have the details. We have just the period he spent in custody, which was total of 5 years and 2 months. He's talking about 39 years or 33 years. It's 5 years and 2 months. That is page 13, but we don't have all the details of those offenses.
That includes the period of preventive detention also.
All included. All included. Total not period would be, if I may say, so not about 8 years all in all cases. So here he was arrested, 2017 in ED, 2019 in this case.
While being in custody, the ED case.
Yes, my lord. And there have been preventive detention periods also not. So total calculation is there. We placed it on record along with this one. So that period is very clear. According to us, Lord, and the cases that he talks about, Lord, my understanding is would not be that 33 years, but 8 years plus. All includes.
Then according to you, what is the evidence and the material against him?
Lord, I've got the material. I've got it here, Lord. I'll show your lordship, Lord. Lord, we have, just to give your lordship a recap, Lord, this is that Kashmir funding case, not where people were put to the streets, where people were being funding those on the streets who were leading protests and making sure that the entire administration would come to a standstill, public life would come to a standstill. So therefore, Lord, we had there is one gentleman called A10 Zahur Ahmad Shah Vatali. Mr. Vatali's bail had come till your lordship's court, dismissed. That's a deported detailed judgment, and which deals with these contours. There, in connection with Mr. Vatali, there was the loose green sheet where we found reflecting payment of 10 lakhs odd to him in 2015. We have a statement of one Ghulam Muhammad Bhatplot who identifies that green sheet and confirms the signature, etc. of A10. We have protected witnesses A67, A69, A79 say that this gentleman used to get medical seats, but so not the way it used to be run was there were recommendations made for medical seats because Pakistan has certain reserved seats for Kashmiri students. So on that recommendation, there was he was one of those people recommending. And then, Lord, there is a statement of one Mr. Bani saying he used to collect money and deliver it to him in Srinagar. And there's a protected witness, John, saying that he was present at the Hurriyat conference meetings along with other people to create what was known as a protest calendar. Not like we have a calendar in the court, they have a protest calendar as to which dates they will do what activity. And to do Jalsa Julus, etc. and stone pelting. Then there is Alpha, who again places him on the spot and saying funds were being generated to create a proxy war. Then there's not scrutiny report of extracted material seized from his house plot. That's AD 116. We have that document. So that's the nature of the material we have against him.
And the stage of trial?
Lord, stage of trial, we've examined 30 witnesses. There were 34 witnesses. There were some, Lord, 350 witnesses. We pruned it down to 290. What 290 odd, we're going to prune it down further.
So after 8 years,
And I'm sorry, Lord. Please let me clarify. Charge came to be framed, Lord. It was argued in detail. 2022 is when I just tell Your Lordship the date of framing of charge. 22, not 16 March 22. Thereafter, one of the accused, Yasin Malik, matter got delayed because Yasin Malik was pleading guilty, Lord. That process happened. After that, the trial has been going on. I have placed on record the order sheet to show that there have been no delays. And I can point this out, Lord. The latest position is till PW 34 we've reached. And if I may say so, Lord, 11 November, PW 31 examined, PW 32 on 12th November, 33 on 22nd December, 34 on 23rd December, and now we're in January. So we're trying to examine 4 or 5 witnesses a month, if as many as we can, Lord, subject to their cooperation. And there are 248 witnesses, and I've already spoken to the NIM, Lord, because I've been special prosecutor in this from the beginning. We are proposing, as this progresses, we'll prune that list down. I don't see us doing more than, at the most, and I must be candid, Lord, 150, at the most 150. Because not doublet witnesses will be dropped. 92 we have already dropped. Without even proceeding with the trial, Lord. That was our first situation.
shall I start, my lord? Yeah.
Yes, Mr. Gonsalves.
And my lord, he's 74 years, so that's the. Now, my lord, page 123.
You want to take that?
No, I don't want to take time at all.
I will take half an hour more.
Wow.
But can I just come back in 10 minutes? He's
Your colleague is here. He will take care of the arguments made by Mr. Gonsalves.
My colleague will just take, I'll be back.
So, my lord, this is the charge sheet.
123, yes.
123, yes, my lord. All the allegations of violence, everything is here in the first charge sheet. I don't see any allegation of violence against me in the charge sheet, in the UAPA
You are not
terrorism
the person
case.
who threw the stones. There is no allegation.
Not
He is
even
the
that I threw
instigator.
stones.
Instigator.
Not even that I instigated to throw stones. It is not there that I instigated. And you've got the statements that I've made, not even a single statement where I'm telling people, throw stones and obstruct the government. Not a single statement. It's a lament of a senior Kashmiri politician, how we were treated, how the army treated us. It's so bad, we should change. We should have all communities come together. It's a lament of a senior politician. And that's why, my lord, if I can digress a little bit, we have these pictures of this Shabir Shah with 6 prime ministers of India who sit with him and try to sort out the situation in Punjab. In Kashmir, sorry,
Yes.
what am I saying? It is inconceivable that a prime minister of India would ever sit across the table in a public meeting where the press is called to sit with a terrorist who is undermining the sovereignty and integrity of India. unbelievable, cannot be done. And you have Prime Minister after Prime Minister asking him what should be done to sort out the issue of the instability of Kashmir. They did it because he was loved. They did it also because they knew he wasn't a terrorist. At the most, he will go to areas where people have been killed and lament the state of affairs. All his speeches are a lament. And occasional speeches where he calls upon Hindus, Muslims, Buddhists to come together to bring about freedom for the people of Kashmir. And by freedom, he didn't mean Pakistan. He meant freedom for the people from the oppression they faced. A bit uncomfortable, yes, no doubt a bit uncomfortable.
All right, so where does your
Yes.
name come from?
Now, my lord, this one, it starts at 123. I'll just read a few things in between and proceed rapidly. This case pertains to the terrorist and secessionist activities that rattled the state of Jammu since the 1980s, early 1990s. Then the names of the organizations come: the LET, the HM, the JNK Liberation Front, etc. Then, my lord, middle of the page, the All-Party Hurriyat Conference, APHC, was formed as a conglomerate of 26 political, social, religious organizations
That is,
in 19.
Why
Just
are
to
you-
give you a quick view, so that you can situate. Then, my lord,
no, you
kindly.
come over to the place where your name surfaces
Role is described.
and what evidence is there in the investigation against you?
Yes, yeah, a little bit, my lord. Now, my lord, the names of the organizations are on the next page,
Yes,
page 125.
yes.
125 onwards, each organization is described.
Yes.
Yes, my lord. Then, my lord, at page 131, the names of the organizations that constitute the All-Party Hurriyat Conference, APHC,
Yes.
is given at 132. Then, my lord, faction fights, etc., 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 etc. At page 135, bottom of the page,
Yes.
the Hurriyat leaders and the joint resistance leadership are staunchly following the secessionist agenda. So this is not me, my lord. Then, my lord, go to 140. Right at the top of the page, again the names of the leaders who are causing, so-called by the prosecution, trouble in Kashmir.
Mr. Gonsalves, why are you taking us through all this? Why don't you come straight away where your name surfaces and what is the evidence collected against
Yes,
you?
okay. Go now, my lord, to the third supplementary.
Where is that? The second supplementary.
First और second में नाम नहीं है.
नहीं,
Third
first
में-
Second supplementary
First
charge.
supplementary. Second supplementary.
Second supplement.
Why
Page-
260?
260?
Yes, my lord.
Yes.
Why I, my lord, was showing you briefly what is there in the first chart. One second. I want to just show you. Show me the conspiracy chart. I jump right in. Go to 178, my lord, in the first chart sheet.
All right, 178.
That is the conspiracy chart,
Yes.
linking all the individuals involved in the conspiracy, the names of the person, names of the organizations. My name is not here, my organization is not here.
All right.
I left, my lord, according to the prosecution case in 96 and formed the Jammu and Kashmir Democratic Freedom Party.
You left the Hurriyat conference.
Hurriyat Conference in 96. It was formed in 93. I left at a very early stage in 96. That is the prosecution case in the charge sheet itself. And, my lord, I formed an independent group. Now, my lord, look at the charge sheet where I am concerned. Page 260. This I need to read to your lordship in bottom of the page, 17.4.1.
Yes. A15.
Yes, well, go to the next page, 17.4.2. Shabir Shah was the head of the Jammu Kashmir Democratic Freedom Party, that is post 1996.
It is a constituent of all parties, Hurriyat Conference. You are a satellite only.
No, not a satellite, my lord. I
A
was
shell
there.
company. What else?
One second. I showed your lordship. That's why I wanted to show my lord a little.
Anyway, continue further.
No, let me show you the constituents. Give me the constituents. In the first charge sheet, at page 132. My name, my organization's name is not here.
That's all right.
And all the allegations are against the all-party Hurriyat Conference. Yes, sir. Now, my lord, go to 17.4.2. Shabir Shah was the head of the Jammu and Kashmir Democratic Freedom Party, a constituent of the APHC. His house was searched on so-and-so, incriminating material, documents and electronic items were seized. Then, my lord, the next paragraph, was arrested in 2019 being part of the conspiracy. Then bottom of the page, my lord. Shabir Shah was arrested in August so-and-so while trying to cross over to. He was released from jail in 1994. So, my lord, here immediately, he is already 5 years in jail. Just this part, this paragraph, 17.4.5. Arrested in 89, released in 94. Then, my lord, in 96, he left the APHC and formed a separate organization, etc. Here. So, my lord, by their own admission in the charge sheet, I am not part of the APHC during its formation and development period at all. Then, my lord, 17.4.6, virulent anti-Indian public speeches. Then, my lord, turn the page, my lord. 17.4.8, was in touch with Pakistan POK-based militant leadership. No material at all. 17.4.9, was duly supported by Pakistani agencies, would receive money from Hawala. No material at all. And the principal persons who brought the money, according to the prosecution case, all acquitted. Then, my lord, at the bottom of that page, 263, in the said case, one Aslam Wani, an associate of accused Shabir Shah, and also a cash mule for the organization, collected Hawala money in Delhi and handed it over to Shabir Shah to be used for carrying out subversive and anti-national activities. The said Aslam Wani was arrested with 63 lakhs received. So, before he could give the money, he was intercepted, money intercepted, and he was arrested. This is a case, my lord, of no material at all. Now, my lord, go to 265. Storytelling. 17.4.12. Shabir Shah was receiving funds from Pakistan through some conduits, substantiated by the documents seized from the house of Ghulam Muhammad Butt, an accountant cum cashier of accused Shabir Ahmad Shah Batali. And I'll show you that document, a loose sheet of paper, not recovered from me, not under my signature, no connection with me, just a loose sheet of paper found in somebody else's residence. Yeah, it doesn't show, my lord, where the money came from, etc. And we are covered by two judgments of your lordship's court. In, my lord, similar cases, loose sheet of paper with a figure and a name. So I'll keep this in mind because I'll take your lordship to that. Then, my lord, go to 266, please.
Yes.
3 lines from the top. Shabir Shah eulogizes militants and martyrs. Shabir Ahmad Shah was regularly being appraised about the Indian Army. No material at all. Now, my lord, go down, please, my lord. Go to the third last slide. So I show you everything against me. 17.4.17,
Why not 1/6, the last 6 lines?
1/6, the last 6 lines?
Yes.
Yes, Lord, give me a sense. In an email dated so-and-so, received from so-and-so, has been received. There is an attachment with subject confidential army report. Therein, the mailer had claimed that both the slain militants were associated with LAT and hated from Sindh, Pakistan. Mailer had warned accused to remain alert in future, also screenshot of this. Nothing against me, Maruna. Then turn the page. Now, 17.4.18. The investigation revealed that in the year 2016, Pakistan government sent an amount of 1 crore 10 lakhs to accuse Shabir Shah to be distributed among. Now, Manoj, this is the loose sheet. It is 1 crore 10 lakhs, but according to the sheet, I supposed to get 10 lakhs. This is the same loose sheet. The loose sheet is one of the 3 pieces of evidence that they had. This is the loose sheet. 1 crore 10 lakhs, and against my name, Shabir Shah, 10 lakhs. Now, my lord, that is the end of the charge sheet. Page 268 is the end of my charge. Speeches, and my lord, Wani gave me some money, and this 10 lakhs loose sheet of paper is the total evidence against me, as compared to the main charge sheet. Now, my lord, go to the charges frame. 182. This is, my lord, 182 of the counter affidavit of NIA.
182.
182, yes, my lord, findings.
Charges at page 34, sir.
182, my lord. In the middle of the page, all-party Hurriyat conference was formed in 93 with a purpose to provide a political front to secessionist activities with the object of secessionism of the state of JK. It was an alliance of 26, etc., etc. Then, my lord, in 2008, they split into 3 parts, and there are 3 factions. I am not part of any faction. I'm not mentioned as part of any faction. Then, my lord, kindly go to page 187. Now, this is the,
This is not the charge. This is a part of the charge sheet.
no, this is the order framing charges.
But the charge is at page 34, annexure P1, annexure R1, I'm sorry. Charge is at page 34.
The charge sheet I read out to your
Where
lordship.
does
Now,
this order start from? Please tell us.
this order starts
From page 95.
95, not this is the order on charge. The charge is at, of 10th of May at page 34.
I'm coming to everything.
No, I'm just saying, just to clarify, because the court was asking, is this not the charge?
Now, this is the substantive order framing charge. And see the mistake made. 5.15. I have perused various statements of cited witnesses. I shall reproduce relevant excerpts. One of them is protected witness John. And I'll show you the statement. A perusal of the statement of this witness shows, take out John's thing, that he closely knows the working of Hurriyat. He has seen accused Shabir Shah, then all the names follow, gathering together in the office of Hurriyat and from there going to different rallies in different districts. The witness states in detail that these rallies were instigations for succession. Pause a while here. So with me, he's put Yasin Malik, Umar Farooqi, Bitta Karate, Zahur Ahmad Shah Watali, and he's talking in a general sense.
Yes.
Yes, Lord. Kindly go to 187, 5 lines from the bottom.
733.
5 lines from the bottom. The witness states in detail that in these rallies there were instigations for
Para
succession.
5.15.
for succession. Now,
Yes.
my speeches are available, and there's not a single speech where I say we must break from India. Go further. Strike calls were given by Hurriyat, not by me. And that during strikes and processions, they would cause the people to pelt stones on security forces. Not a single statement by me. Attack the security forces, throw stones at them, destabilize them, hurt them. Not a single statement. Then we'll go down further. They means everyone together. And this is the way the order framing charge goes. And in the end, you will see that all that is attributed in the main charge sheet, which I wanted to read out to your lordship, is taken as my conduct, not my charge sheet alone. They would collect funds as zakat and through other measures, and these funds were used to fund and help stone pelters and families of killed terrorists. They would claim as martyrs. The only specific thing for me is that when a stone pelter came to my house and he was being arrested, I gave him a lawyer, I gave him his name, and I told him, go to this lawyer, he'll do your case for you. After the killing of any militant, they would get stones pelted from upon security forces. It specifically mentions that the accused Shabir Shah being closely connected to stone pelters and providing legal help to one of them, namely Danish. That is the help I gave him. That is correct. It is contended, etc., etc. However, this witness connects Shabir Shah, Yasin Malik, Bitta, etc., etc. to it. In continuation of this, other witness, AW62. This is one. AW62. This is John Miller. I'll show you John's statement. Completely innocuous statement. One stone pelter, Danish, and states that his name was saved in the phone of Shabir Shah. This stone pelter was a regular visitor to the house of Shabir Shah, and that on his arrest, Shabir Shah provided him with a lawyer. He further goes on to state, etc., etc. Then he talks about Yasin Malik and so on. This witness further goes on to state that after the killing of terrorist Burhan Wani, now, my lord, Burhan Wani was killed in 2016. And at the time of his killing, immediately after that, I was in jail for a protracted 2017 till today. So Burhan Wani killed in 2016, disturbances in the valley. I was in jail during that period. And I'll show you from the record. After the killing of terrorist Burhan Wani, there was unrest in Kashmir, and on the directions of Shabir Shah, rupees 35 lakhs were collected from a place, and on his direction, this money was distributed to, even assuming this is true, pellet victims and stone pelters. No record, no evidence, no material that is of 35 lakhs. Around 14-15 lakhs were distributed, and the remaining 19-20 lakhs were kept by Shabir Shah for himself. Now, my lord, go now to page 195.
Yes.
10 lines from the bottom of 195. He further states that after the killing of terrorist Burhan Wani in 2016, there were huge protests. Correct. People were injured in these protests. Correct. And Pakistan instructed these organizations. These organizations were so-and-so, headed by so-and-so. Freedom Movement headed by Shabir in jail. 2017 till today. And so-and-so, so-and-so, so-and-so. These organizations thereafter received 1 crore. This is the same loose piece of paper through Hawala for the aforesaid purposes. Families of the person who were killed in these protests were given rupees 1 lakh, and this money was given to them through Shabir Ahmad, who was the driver of the accused Shabir Shah. This part of the testimony was corroborated by one witness, AW62. So apart from the statement, there is no material that I distributed to the victims 1 lakh. Now, my lord, go to 201. Your Lordship can skip that. Go to 224. The above analysis reflects that the statements of the witnesses and documentary evidence has connected almost all the accused with each other and a common object of secession. So this is the conspiracy chart that I showed your Lordship. My name is missing. To the commonality of means that they were to use, their close association, etc. Witness after witness have deposed that APHC, its factions after division, and JRL had only one object, and that was the secession of J&K from the Union. Witness John has connected Shabir Shah, Yassin Malik, Shabir Ahmad Shah, Vatali. I'll show you that statement, my lord. Shall we show it right away? Just go straight away to 212.
Yes.
And then I'll come back.
2 of this very order.
Of my lord, the SLP. Just open to the SLP, my lord. Lumping me together with the APHC and general statements, overarching general statements. This is the best they could produce. 212. This is their ace of spades, their trump card. 2 trump cards, John and 1E. Lordship has that, my lord?
212, yes.
212. I was born and
Statement
brought
of
up.
John.
This is John, yes, my lord.
Yes.
Go to the second paragraph. I start from the beginning. I was born and brought up in Kashmir. I was an employee of the Hurriyat Conference. While working there, I saw Gilani, Shabir Shah, Yassin, Umar Faruqi, etc., come to the Hurriyat office. And so and so would come. All these people would go to different districts for processions. In these processions, people would be told and provoked to get independence from India. The people whose names, and my lord, remember, the latest speech is 22 years ago, 1993, by their own admission. I'll show you that. 20 years ago. The people whose names I have mentioned above in my testimony would call them from time to time for a strike with people. That part would be correct. They would call them and say, let's strike. So-and-so has been killed, so-and-so has been killed, so-and-so has been killed. They would state in newspapers that today is a hartal for this and later is for that. All these people, now lumping me together with everybody, would during the processions make the people throw stones at security forces. They would gather money from people. The money that was collected was called. Later, this money would be used by the Hurriyat. All the leaders, Shabir the page, Malone. Go to the bottom of the same page, 212. Over there, Aga Hassan gave Shabir Shah's representative a bag. He said there was money in the bag. He went and gave this money to Shabir Shah. He had 2 mobile phones. The mobile numbers are Shabir Shah's contacts his relatives in Pakistan using these numbers. No CDR, no material at all. When militants would die, after that they would get stones pelted. Young boy named Danish who used to pelt stones. He was arrested once. So his father came to Shabir Shah and told him that Danish had been locked up for 6 months. So Shah Sir provided him with a lawyer to get him released. Everything that I know, I have said. This is the only particularized statement of assistance. Now we go to? Yes, well, now go back, but kindly, my lord, to 224 of the count of the counter of the NIA. This is a no material or very scanty material case, considering that I've been in jail for such a long period of time. With every FIR saying the same story. 5.86. The above analysis reflects the statements of all the witnesses and documentary evidence has connected almost all the accused with each other to a common object of secession. Witness after witness has deposed that the APHC, its factions, its divisions, one object. Witness John has connected. I've read this out to you, Lordship.
All right.
Now, my Lord, 225, 10 lines from the top.
Yes.
Even otherwise, none of these accused, except accused so-and-so, have denied having been associated or being part of the APHC. Clearly, I said 96 I left. Prosecution agrees 96 I left. Now, my Lord, kindly go to page 227. And on the basis of lumping me together with charge sheet number 1, the main charge sheet, this is his conclusion, 6.4. The evidence discussed so far raises a grave suspicion that accused number 1 to 10 and accused number 13 to 16, I am 15, the accused number so-and-so, aided and abetted Pakistan establishments, entered into an agreement to work together for achieving a common object. The said object was secession. They further agreed to be commonly called for support and organized strikes, etc., etc. So they lump all the accused and all the charge sheets together. Now, my Lord, 230, bottom of the page.
Yes.
6.11, thus prima facie, a grave suspicion arises of the accused number 1 to 10, 13 to 16. Accused number 18, section 120B, where the conspiracy chart is given, my Lord, in the charge sheet, in the main charge sheet, where I am excluded from the conspiracy chart. Lumps me again. Yes, my organization and me. Then, my Lord, 231, top of the page, lumping again. Prima facie, 13 to 16, section 18 of UAPA. And it goes on like that, my Lord. Now, my Lord, kindly go to 248. Again, bottom of the page. Last 3 lines.
Yes.
Raises a grave 1 to 10, 13 to 16, 18. It comes like that in a mechanical fashion, right through the charge, the order framing charge. Etc. Then 249, para 8. Punishable under 18. 18 is conspiracy. Then 250, 9.0. 9.89, just above 9.0. 121A, waging war. Then, my Lord, 251, 9.4. 121 IPC, 9.4. Then, my Lord, just above 10 at page 252, just above para 10. What section? 121. Then, my Lord, 10, terror funding. Now, my Lord, see that loose piece of paper. 253. 253, my Lord. Top of the page. The only document they have in this entire case. D132 is a document which was recovered. Your Lordship has that, 253?
Yes, yes.
250.
You have that loose paper
Yes, you have that. my
bearing
Lord.
the date and the amount.
Yes,
The
my Lord.
signature of one of the accused.
Zaur
No, that is, my Lord, the accountant.
accountant.
Vatali's
Accountant of
accountant.
Vatali.
Somebody else's accountant.
Yes,
he put.
yes.
Now, my Lord, the actual paper is at 368.
But in fact, what 10.2 says it is a Vatali. There are 10.2 at page 253, 254 bottom. My friend Majid.
368.
Yes.
where they type my name on a loose piece of paper.
Signature is of Patali only.
Yes, not 10, para 10.2,
There's
not.
a handwriting expert's report.
Yes, no, there's a report, not, and 10.2 is the para, 253, 254 bottom, 253 bottom.
Now 368 is that loose piece of paper.
That document has been tested till this court in the
No.
bail of Batali.
Okay.
In Watali's case, maybe. Yes, Lordship saw Shabir Shah, 368.
368 from the SLP or the reply?
This is in the reply.
268. 268 is equal.
To 368, sir.
368.
In the reply.
Yes, Lord, 368. Sorry.
That's the loose sheet.
Yes,
Oh,
Lord.
printer. Oh, yes, yeah. Better printer.
Printers.
Shabir Shah received 10 lakhs on 29th April 2015.
We don't know, sir. It seems to imply that it simply said date so-and-so Shabir Shah. Who received, who gave, when was it given? Nothing at all. Now, my lord, go to 1E. So the first trump card is John. John gives a generic statement that he used to meet with all these kind of people and he gave legal aid to Danish. Now see, my lord, the next one, 256. 1E was their main witness. Now, my lord, go to 256.
Page 256
Yes, my lord.
of your SLP.
Of the same.
Same
Order.
Yes, my lord.
All right.
Go to my lord, roughly 10 lines from the bottom. There is a witness which reflects the accused Shabir Shah had received money from Pakistan and to whom it was distributed. There is evidence that the money sent for these activities from Pakistan to accuse Shabir Shah was collected by a witness in Delhi, Mr. Wani. That is PAW81. AW80, protected witness 81. And once transported to Srinagar, whereas on the second occasion, he was apprehended and there is evidence that accused Shabir Ahmad Shah Watali has been receiving huge funds. So on his way to giving me money, he was apprehended. And I'll show you the statement as well, so that there's no ambiguity.
What exactly do you expect us to appreciate all this evidence and record a finding?
No, I want to only tell your lordship that I want to establish, as opposed to what they will tell
The
you.
witnesses have stated.
What the
now
very
they will
serious
disclose before the trial court on oath, you will have a right to
No, I
cross-examine.
get that, sir. Today I'm asking for bail.
Yes.
I don't
Mr.
want to
Gonsalves,
ask.
Mr. Gonsalves,
I understand that. Yes,
section
sir.
43 is there. These findings are there in the order framing charge, which has attained finality. We don't know whether you have challenged it or not.
I'll tell you that.
Yes,
So that was challenged
yes,
in the High Court. In the High Court, it was challenged by way of an appeal under the Act.
right.
The stand taken by the prosecution was the appeal under the Act is not
Not
maintainable.
maintainable.
That was upheld by the High Court recently, 2-3 months ago, 15 days ago.
Hmm.
And that will be challenged by
But in the meantime, the trial has already proceeded. So
hardly
Hardly means
for the trial. I'll tell you,
30
I'll
witnesses.
tell you, my lord, 30 witnesses out after scaling down the witness.
Yes,
Earlier they had how many?
300.
400. After scaling 400 down, which comes now in the counter, 400 to 290. 30
Now they have
witnesses.
come down to 245.
they are further scaling it down.
248 and we'll.
But my lord,
I'm telling your lordship,
it's too late now.
I'm
After 8 years, in such an important case, if you could only do 30 witnesses and you have 200, whatever, 140, 190 witnesses, and 8 years have passed, I rely on all those decisions like, yeah, and Justice Suryakant's order.
The recent.
Najib, Vernon, 6 judgments following in line. That if you have delay, you have to release now. And in my case, it's not just delay. Najib's case was 3.5 years delay.
8 years.
3.5 years delay in Najib's case, sorry. This is 8 years.
Najib was 8, sir.
Najib was 3.5 years. Now I'm going to go to 266. To answer your lordship question, I don't want to only argue on delay. Delay I'm going to do, definitely I'm going to do, but I don't want to argue only on delay. Because they will create a picture of a spectre of a terrorist, so deadly that even if he has got 8 years, 9 years, I will show you 35 years. It doesn't matter. And why I read the charge sheet is not a significant charge sheet at all when you compare it with the main charge sheet. You base yourself on terror funding. Terror funding is 17. You based yourself on that. And on that, we have an acquittal of the person giving the money, so-called, and the person taking the money. Shabir Shah, acquitted, and bail.
Shabir Shah is on bail.
He got
Wani
bail
has-
in the ED matter
Wani
on
has-
terror funding.
Wani has been acquitted.
Wani has been acquitted.
Not in this case, not. One is
In
not
the ED case, one
ED.
second. ED case is the same case. That you got same amount. You got this amount of lakh of rupees and you were caught and you were found with this. Same amount, exactly the same.
Sir,
What's
that's
the
the
amount?
Delhi police separate case, not in the ED case. Delhi police separate
In the
case, you
ED
place
case.
that judgment, High Court,
ED
the
case,
state
ED
went
case.
up, High Court lost. In the ED, there's a ED arising out of this which is separate, and I understand there is no acquittal because somebody else is the special PV.
We'll show you the acquittal.
In the
Upheld
ED
by
case-
the High Court.
in the ED case.
Of Wani, yes.
In the ED case, all right, please.
Yeah, now you wait a while. Let me finish. I'll show
Sir,
you everything.
Not an ex.
I'll show you the order.
It's by the state. When Radhika Kuluru had appeared in the matter, it's by the state, I'm very clear.
Mr. Luthra,
Okay,
how
I'll
much
show your
time
lordship. I'll show your
will it
lordship
take to
the
conclude?
orders.
I'm sorry, not.
How much time do you think you take to conclude the trial?
But I must tell your lordship, we are in the process of pruning. I've taken instructions not before this. We're in the process of pruning down the witnesses more. If they were to cooperate not, we will at the most.
No. Is it your case that the trial has not proceeded courtesy their
Not they be. I put those orders not showing that there has been great delays on their part.
4 days. 4 days in 8 years.
Lord, I think the question was.
I've got the orders. I've got
My
everything.
lord-
He's given it to
Lord,
me, thanks to him.
I must say this. Now, let me just debunk the myths that we are being.
So I'll argue. Then you debunk my myths. 4 days.
Can I respond to the court's question?
4 hearings of the
My dear
court.
senior, can I respond to the court's questions?
I'd rather finish, Manoj, and he'll do it comprehensively.
what more do you want to argue? You argued everything.
No, sir. I don't want to leave it incomplete. The man is very sick and he's old. And I came, my lord, we filed also health things and all that. He is very sick. This is my last chance. I'll argue it fully, with full, my lord, effort from my side. I'll argue that I'll leave it to fate. But I don't want to leave it half done. And I don't want
My
to
lord,
argue
I-
only
I-
on
I
only
just
on
one thing to
delay.
say.
I want to
Having-
show this man deserves to come out.
Having lost in the charge, Lord, albeit on maintainability, he's been knocked off. He's not challenged beyond that.
Few days ago, sir.
Sir, can I just complete my sentence? Having lost on that, para 26 of Vatali will stand in his way on the merits of the matter. They will, so not the only thing, if at all, is delay. On delay, the High Court Lord has dealt with this issue and the High Court has given a finding in my favor saying specifically, as far as the plea of delay of the trial is concerned, the appellant has been in custody for 5 years. Charges have been framed, trial is underway. There is no delay on the part of prosecution for examining his witness, as is evident from the affidavit. I'd filed an affidavit placing every order sheet on record. Even here, I placed the orders, Lord. I've not hidden from that. We are proceeding. If they were to cooperate, not we would be able to proceed
By
further.
their non-cooperation, what do you mean?
Lord, if I may say so, Lord. If they seek an adjournment or
But
they.
precisely how many adjournments they have
No,
heard
Lord,
over
Lord,
different
that I'll have to. That I'll show you.
from the
Lord.
date of filing of charge sheet.
Yes, it will show in the order.
With that affidavit.
And I'm asking for a time.
Just give me.
4 for all defense counsel together.
So,
Not just
kindly
me.
just see page 19, Lord.
Take a
Page
page.
19 of my count.
of
My
what?
counter, Lord. My counter. Page 19.
Which are the ones?
Page 19. Yes, Lord. Page 19. I put the table, my Lord, to point out the reasons for adjournment.
Yes.
Lordship's got it. These are the orders, not page 19 onwards. Does your Lordship have it? After the Lord, charges are framed in May of 22. Yasin Malik is guilty. Not thereafter, list of documents for admission denial. They sought 3 adjournments, refused to do admission denial. They are entitled to do that. Thereafter, Lord, we started examining the witnesses. And my Lord will see we placed on record how we have been proceeding on a day-to-day basis.
See page 20, sir. See my adjournment from me, on my account. On account of all defense counsel. See page 20,
Lord, I'll show
16/7/22, 28/22, 31/8/22, and then my lord turn to page 22,
Sir, 16 July.
6/4/24.
Sir, please,
4.
16 July, you took time. 20th August, you took time.
Correct.
31st August, you took time.
Correct.
Thereafter, no, I'll just complete. Of 22. Thereafter, yes.
Page 22,
just a minute, sir.
6/4/24.
Page 21, sir. Page 21. First, let me come to that. Thereafter, Lord, 4th September, 4th July time is taken. 4th September time is taken. And
No, look at it. 4/7/23.
6th of April.
No, look at it carefully. Please don't just.
19 December 23, 6th April 24. Thereafter, Lord, on 23rd October, Lord, the court's outcome clarification. Then, Lord, there was an issue regarding whether this was the competent court, Lord, because there was an MP MLA, because one of the accused became an MP, Lord. That's not 13 December 24 onward. There was this issue was going back and forth as to whether the matter could be heard for Engineer Sheikh, Lord, because he became an MP in the meanwhile. On 20th February, you'll find that issue was going on. On 8th of May, we again started, Lord. 8th of May, between 8th of May and now, Lord, we've examined about 12, 13 witnesses in 6 months. And please see, 13th of May, they took time. 14th of May, 25th, they took time.
Where is that 13th of May?
20th of August,
Wait,
just a
13th.
minute. 20th of August, they said they don't want to examine, fair enough, Lord. And thereafter, we are now at the latest order sheets, Lord.
No, this
which are
is
here.
defense counsel for somebody else, not me.
Sir, there are
I have not
15
taken a
accused.
sing-
There are 15 accused.
That would be cumulative. That can't
Yes,
be-
sir, for that, they have to do a day-to-day trial if they want to be within the time limit. When they know there are so many accused and you do one hearing a month. One hearing a month. You know it is going to protract.
We are taking 2 to 3 hearings every 15. We
The
are
dates are
asking
here.
for earliest dates.
If you have 400 witnesses, even if you do 2 hearings, you'll go to the 10th year easily.
I'll show you, Lordship. Now, this is the current position.
You must do day-to-day trial in a case like this in order to meet the Najib standard. Can I argue or you started
No,
arguing?
I've given the court the order sheets on this.
Read it and mark it. We have read all the order sheets. We have not asked for time. Defense counsel may have asked, and I maintain the following are the dates: 16/7/22, 28/22, 4 dates.
Lord, the order, Lord, will be at page 1, 2,
Highlight order sheet.
then page number 5.
Highlight the order sheet. Carefully.
Thereafter, page number 12.
All right.
So how much does it come to cumulatively?
So page number 17.
All right, Mr. Luthra, let Mr. Gonsalves complete.
Yes, sir.
Yes.
Well, I think he will take time. I'll just be back. in 5 minutes.
You.
Where to go? Yes, I've shown that. I've shown the look sheet. And is that done? Give me a second, Malone. Number 266, bottom of the page.
Mr. Gonsalves, one
Yes,
small query from you.
Yes, ma'am.
You argued on the merits of the matter, right? You are referring to the merits also.
Yes, ma'am.
You also propose to challenge the order framing charge.
Yes, ma'am.
So supposing you invite a finding from us that on merits.
So
you
I'll
don't have
take my
any-
chance, sir.
Very well. That's
Whatever
what we-
happens, I have to take my chance.
That's what we are trying to
I don't have time anymore. ma'am.
Okay, very well.
I thought about it. If I wait, if I challenge it, how long it took, my lord, in the High Court to have the matter dismissed on maintainability itself.
Good.
I think it took how many years?
Luckily, the trial didn't
3.5 years.
Trial didn't wait for that. Trial started. Thankfully.
In a desultory fashion, my lord, hardly.
Whatever the fashion is a different issue. At least it has started.
3.5 years it took for the matter.
All right, you come back to your page number
Yes, my lord, yes.
2
Where was I? What?
of the SLP or counter?
Yes, my lord, this is of the reply.
Page number?
266.
266. Yes, 267, paragraph 10.25. This is the main particularized chart and charge on terror funding. Details of the person, details of the time, and details of the amount. And then I'll show you, my lord, the trial court order, the high court order, acquitting them.
Yes.
10.25. The statement of AW81 Aslam Wani, who states that on 2 occasions, on the instructions of accused Shabir Shah, he had received money in Delhi from people who were connected to Pakistan-based.
257.
On the first occasion, he received,
Yes.
acted as a mule and successfully delivered it to Shabir Shah in Srinagar. So successfully delivered. On the second occasion, he had received 20 lakhs by contacting some Pakistan-based number, which was told that he was to receive a second installment on the next day. The entire money was to be taken by him to Srinagar and delivered to Shabir Shah. However, on the second day, he was apprehended. So 15 lakhs was given. The second got caught up because he was apprehended. The testimony of this witness at this stage can also prima facie establish the role of the Pakistan-based agency in terror funding and accuse Shabir Shah receiving that money. Then, my lord, the rejection of my argument. Okay, 10.26. Yes, 10.26.
Yes.
Here an objection has been taken on behalf of the accused Shabir Shah that the statement of this witness under section 161 cannot be considered, as this witness was tried for various offences, including section 17 UAPA, and was acquitted of all the offences under UAPA. This judgment was upheld by the Honourable High Court and not carried further. So Wani is in the clear. The man who gave me the money is in the clear. Now, my lord, go to page 269. Top of the page, my lord. At present, the state of Aslam Wani is of a person who has paid his dues to society by serving his sentence for the crimes committed, and nothing bars him from becoming a witness in this case. And thus, at this stage, the argument that his statement is per se inadmissible, cannot be accepted. Then, bottom of the page, my lord, clause small 4. The accused Shabir Shah was the direct recipient of this terror funding. And then bottom of the page, grave suspicion. Then, my lord, 279.
Yes.
Again, my lord, terror funding, 11.14. I'm not reading this out again, my lord, because it's come before. So on terror funding, my lord, According to me, my lord, the case has been knocked out because of Vani's acquittal and so on. I'll show you those orders. Nothing. Number 319.
319?
Yes, my lord. Para 13.7.
Yes.
The accused Shabir Shah, the documents which have been pressed into service to establish that he has committed offences under 38 and 39. It is contended that these are emails dated 16/4/14. Translation of the attachment to that email which has been received by this accused from one so-and-so has been set, etc., etc. This email, my lord, is at page, give me the page. And this email is totally illegible. Give me the page. (266)
Yes.
SLP or
of the SLP, my lord. I'm sorry. Yes. No. 266. Just above the last paragraph. Then, my lord, kindly go back to 320 of the counter. And see with what broad brushes in a criminal case this storytelling continues. 13.7.2.
Page 3.
No, my lord, just forget that. 323.
323 was a counter affidavit.
Yes, my lord, sedition. This may be. Sedition is bottom of the page 323. Shabir Shah A15 and so on. So evidence has been pointed out in the synopsis of evidence to reflect any statement, either written or spoken, given by them or any act as enumerated under 124A IPC, being done by them which would have brought or attempted to bring into hatred or contempt or incited or attempted to incite disaffection towards government. Accordingly, there is no evidence to raise a grave suspicion of these accused committing offense under 124A, asking for insurrection, asking for all this kind of, my lord, hate against India and so on, revolt, throw stones against the army. 124A would have come into force immediately. The speeches followed by actions. 124A, no evidence at all against me. Your speeches get knocked off with this finding. Now, my lord, that's it. Right? Now, my lord, what is this? Yes, my lord. Now see the impugned order of the High Court. See the broad brushes and see how I'm lumped with everybody. I just show you, my lord, a few paragraphs. It's a short order. But I'll show you, my lord, how the High Court went. Page, my lord, 23 of the SLP onwards.
Yes.
Now, my lord, go to paragraph 58 at page 25. No, paragraph 60.
Yes.
It is the prosecution's version that even though the appellant has been in a long period of incarceration in different FIRs, his involvement in the present case specifically pertains to the hatching of a conspiracy. I've shown you the conspiracy chart. I'm specifically excluded. And apart from the said video, substantial incriminating evidence has been collected. The material evidence collected by the investigator has unearthed a deep-rooted conspiracy. The charge sheet excludes me, and you bring it in and say it shows a deep-rooted hatched in secrecy, in which the
Charged for 120B. You have not been discharged from 120B.
correct. So
What-
now my new appeal, when I file it,
Uh,
it will come because we were all waiting.
You are
for-
arguing that you have been discharged from the allegation of conspiracy also.
No, sedition.
Sedition only you have
We understand.
Sedition 124A.
Correct.
And my lord, on 120B, there's no charge against me.
Here only the High Court is.
Yes, I know, but I was
conspiracy.
excluded from that chart. The chart of conspirators. My name does not figure. My organization does not figure.
Oh,
But there is a formal charge of 120B.
Yes, my lord, it came in like a side wind, but I'm not there in the real chart showing every conspirator.
Two charges, mainly charges against you are of terror funding and conspiracy. These are the two charges only.
Sir, if I may say, it's terror funding and speeches.
Speeches, yes.
These two.
Hate speech, the inflammatory speeches.
There's no charge. If you see what I read out to your lordship, conspiracy with A, B, C, D, nothing at all. Yes, I gave speeches and I got terror funding. Now, I'll go to the bottom of page 26.
yes.
Paragraph 60. So, my lord, that argument is brushed aside, not even prima facie looked at, that in the chart of conspirators, my name does not figure. Bottom of the page 26. This is not the stage to consider. Prima facie. What Ali's case, my lord, has been departed from in this by this court in 4 judgments now. And in those 4 judgments, benches of the same strength have held, you must do surfacial analysis. Not go into detail as if you're conducting a trial, but you must look at what is prima facie obvious. I'll give those judgments to you. And 65B certificate for those videos, which you can't make head or tail out of. We'll look at it later. Now, my lord, kindly go to then, my lord. Para 65.
Yes.
To further establish the conspiratorial role of the appellant, the learned senior counsel for the respondent pointing towards statement of various protected witnesses and documentary evidence, from which it prima facie culminates that the appellant had received several calls from so-and-so during the period so-and-so to so-and-so. No CDR, no material. I'm saying it again and again, no material. Now, 66. The position of law is well settled and the court is not required to adjudicate upon the admissibility, agreed, or credibility, agreed. But you must do surfacial analysis. Supreme Court now in its judgments have said, you can't just take the prosecution version and follow that. That was Vatali, 2-judge bench. 3 courts after that from your lordship's court, 3 benches. You must do a surfacial analysis and come to a prima facie view. What does the court do here, my lord? See, we may note that the position of law is well settled and the court is not required to adjudicate upon the admission. Correct. At the end, under the U. And this is not correct. The evidence on record is to be taken on as it is basis. Namely, what the prosecution says you must accept while granting bail. That is totally wrong. And the law is not clear. After Watali basically inched towards saying, whatever is stated by the prosecution, you have to take it, virtually. But now the judges have, 6 judges, 3 benches have taken a contrary view. We can't just take the prosecution case. We must look at the surface analysis of it. Now, my lord, kindly go. Then, my lord, everywhere, my lord, the Rani just said. Now, my lord, paragraph 70. Learned senior counsel for the appellant has drawn our attention to the affidavit filed on behalf of, which outlines the details and status of 24 FIRs registered against the appellant and submitted that it is evident that most of the FIRs are more than 10 to 15 years and the appellant has been in custody for an unreasonably long time. Paragraph 72. Now, this is held against me. It is not denied that the appellant is in custody in connection with these FIRs. During the course of proceeding, queries were put to the learned senior counsel as to whether the appellant was applied for bail and so on. So, the counsels could not give a clear and satisfactory response as to whether any bail application, whatever we had, we gave. But we have a completely incomplete record. Nonetheless, the fact remains that the appellant continues to remain in custody. What is evident is that the appellant has multiple FIRs involving rape. Remains a mystery if a bail application has been filed, the result thereof, and if not, why. Now, just give me, I'll go quickly now. Now, see, delay. We must, my lord, stop this drift in these cases, my lord. Para 78.
Yes.
As far as the plea of delay in trial is concerned, though the appellant has been in custody for 5 years, wrong. I'll show your lordship the custody chart. And I maintain that it is 37 years in jail overall, detention, and the charges have already been paid. The trial is underway. There is no delay on the part of the prosecution for examining witnesses.
So, Gonsalves, you have been repeatedly saying 37 years or whatever it is.
Yes, I'll show now.
1 minute.
Yes.
But how is that relevant if you are inside for some other offenses committed
yes.
earlier? Why are you repeating that? In this
I'll
case,
tell
you
you
are
what-
there since 2019.
Yes, my lord.
That's the end. There's no dispute on that.
Yes, my lord. My answer is this, my lord. I was in a series of FIRs. It was my case before the courts below that the FIRs are akin to the same FIR, namely that I gave speeches. From the first
No,
FIR,
those FIRs don't have any
UAP.
UAPA or
UAP?
terror funding.
only Wani comes new. But all of them must be
UAP.
correct. Wani comes new. But every FIR says speech.
There is shared.
Every FIR says speech.
Eh, see, four more cases in which UAP has been applied.
No.
Mr. Gonsalves,
Yes, my lord.
the first FIR against you as per the chart at page 32 is of the year 2015.
2015.
15.
Just
Right.
check out my chart.
Page 32.
Yes, just let me, my lord, have a
This
look.
was
Give me-
presented by you only.
उसके पहले के भी cases है ना 16 of
2014,
10,
15.
there was one in
2001
2001.
Look at item number 7, 95.
Yes.
Yes, 99.
Then look at item
95,
number 8,
96.
96.
So now, if you are arguing that you are in custody for last 35 years, what is the detail of your custody in these cases?
I'm showing you, sir.
Yes.
I'm showing you. Just wait a little while. But the first FIR was somewhere in 95
Oh.
and then goes up. Now, my lord, I'll show your lordship that. Let me go in my way. Now, my lord, go to my written arguments.
Have you filed a soft copy of your written arguments?
Yes, my lord.
When did you file it?
What is the date of this? 10/12/25 or thereabouts.
You have spare copies of the same?